All right, this lawsuit is going to make a Kafka novel look like nonfiction. Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie. You might notice that the audio is going to be a little off for this video. I seem to have lost my mic while I was scooting to or from or at the anti-lockdown protest on Saturday in Montreal. I hope whoever found that mic on the ground can make good use of it. I'm going to order another one, but in the meantime, I'm using the native mic on this Nikon, so it's not going to be all that great audio quality. All right, so with that disclaimer, this lawsuit is going to make a Kafka novel look like nonfiction. It's going to make Kafka say to himself, how did I not think of this? All right, so this was reported by the New York Post, and no, I do not only believe that which I read in the New York Post, but I'm going to go over the article because it summarily goes over the facts of the case. Then we're going to go over the judgment, which grants in parts and dismisses in part the defendant's motion to dismiss under a Rule 12b-6.
Klaus is a moron who knows only what he reads in the New York Post.
Ex-UVA student can sue school after asking questions during a panel got him expelled. Judge. Now, this is actually one of the few examples when the headline of the article actually does an injustice to the absurdity of the substance of the article. A former University of Virginia medical student can proceed with a lawsuit against the school over his expulsion, which stemmed from questions he asked about the nuance of microaggressions during a panel discussion that led to him being branded a threat, a federal judge has ruled. This medical student asked questions during a panel on microaggressions and it led to him being expelled. Talk about proving a point. And wait until you hear the details of what he dared ask during a panel on microaggressions. The trouble for Bhattacharya began in October 2018 when the then second-year medical student attended a panel discussion on the subject of microaggressions. The term is defined by Merriam-Webster as, quote, a comment or action that subtly and often unconsciously or unintentionally expresses a prejudiced attitude toward a member of a marginalized group, such as a racial minority, end quote. Basically, after this panel, there was a Q&A session where Bhattacharya asked a couple of questions, lasted about 5 minutes, and what ensued after that is the stuff of Kafkaesque nightmares. During a question and answer portion of the panel, Bhattacharya sought clarification on the definition of microaggression, asking the presenter, Assistant Dean Beverly Cowell Adams, if only marginalized groups were impacted by it, court records show. Adams said it was a, quote, very good question, end quote, and the answer is, quote, no. And then Bhattacharya cut in and said her slide indicated victims of microaggressions must be members of marginalized groups. Quote, so that's contradictory, end quote, Bhattacharya said, according to court documents. There was some back and forth between Bhattacharya and Adams as to how you define a marginalized group, what could be understood as being a microaggression. I'm going to flash a screenshot from the article so you can read it yourself. A link to the article will be in the pinned comment as well, but we need to get into where this is going,
because it's gonna blow your mind.
In total, Bhattacharya, Adams, and the other dean debated back and forth on the semantics of the term for just over 5 minutes during the event. Later that day, assistant urology professor Nora Kern, who helped organize the panel and was in attendance, filed a, quote, professionalism concern card, end quote, against Bhattacharya, saying he, quote, asked a series of questions that were quite antagonistic, end quote. A professionalism concern card? What in the name of God's green earth is a professionalism concern card? Like they're playing soccer and someone just got a foul and got a yellow card. Except it's a professionalism concern card because somebody thought he was a little antagonistic and didn't like him challenging the dean in their thoughts. Quote, he pressed on and stated one faculty member was being contradictory. His level of frustration, anger seemed to escalate until another faculty member diffused the situation by calling on another student for questions. I am shocked that a med student would show so little respect towards faculty members. It worries me on how he will do on wards, end quote. Kern wrote, court records show. You can't make this stuff up because if you did make this stuff up,
nobody would believe you.
Suggesting that a professor might espouse contradictory beliefs is somehow an act of aggression that warrants a professionalism concern card, and just wait until you see how this does not stop escalating. An assistant dean at the school then asked to meet with Bhattacharya, saying he observed his, quote, discomfort, end quote, during the panel and wanted to help him, quote, understand and be able to cope with unintended consequences of conversations, end quote. The unintended consequences that people looking for microaggressions find and create themselves, and it doesn't stop here. Ultimately, it leads to the kid getting kicked out of university and having a non-trespass order issued against him because they deemed him to be a threat. Let's get there. Quote, I was quite happy that the panel gave me so much time to to engage with them about the semantics regarding the comparison of microaggressions and barbs. I have no problem with anyone on the panel. I simply wanted to give them some basic challenges regarding the topic. And I understand that there is a wide range of acceptable interpretations on this. I would be happy to meet with you at your convenience to discuss this further, end quote, the student replied. And you want to talk about microaggressions and hashtag confession through projection? Wait until you see what happens at this point of the story. While another dean asked to meet with Bhattacharya, the Academic Standards and Achievement Committee met to discuss the concern card and decided to send the student a letter to remind him to be respectful and professional and to suggest he get counseling. This is not a joke. They suggested he get counseling, talk about not so microaggressions, as if to suggest that he has mental disorders or some rage problem that he needs counseling for because he engaged in a 5-minute debate with some professors. But alas, as is the hallmark trait of all tyrants, the suggestion was not a suggestion and quickly became a requirement. However, that suggestion soon became a mandate, court records show. Bhattacharya received an email in late November saying he must be evaluated by the class school's Counseling and Psychological Services office before he could return to class. When he asked what exactly he did wrong and under what authority the school could mandate that he be psychologically evaluated, he was invited to attend an ASAC meeting that was convened to discuss his enrollment status, court documents say. They convened this student to a meeting to discuss his enrollment status. That is code for you're getting booted from the university. And when they convened him to this meeting, apparently with 3 hours notice, he showed up, took a picture and recorded the audio of the meeting. And the people there didn't like that very much. Just look at all of their embarrassed faces in this picture. Maybe I am reading too much into it, but this picture captures the embarrassment of tyranny in action. At the hearing, which Bhattacharya claims he was only given 3 hours to prepare for, the student recorded audio and took photographs of the attendees and was criticized for doing so. He was told the reason for the hearing was because of recent concerning behaviors and interactions at the panel meeting and after. The group voted to suspend Bhattacharya for, quote, aggressive and inappropriate interactions in multiple situations, end quote. And about a month later, UVA police demanded he leave the campus for allegedly making threatening comments on social media platforms. Bhattacharya later brought a suit against the school alleging it violated his First Amendment rights, his 14th Amendment right to due process, and conspired to interfere with his civil rights and injure him professionally. The school said Bhattacharya didn't have a claim, calling the allegations, quote, baseless, end quote, and wrote in a brief that he was thrown out because he violated the school's professionalism standards. A federal judge agreed with the school in part and dismissed every count except for the First Amendment violation, which he upheld, allowing the case to move forward. Now, full disclosure, I think I tend to be on the side of the student here, and by I am on the side of the student here, but I would nonetheless take allegations of threatening behavior on social media to be relatively serious. But the lawsuit does not add any details to this allegedly threatening behavior on social media, neither do any of the correspondence from the school to Bhattacharya, so maybe the allegations were left out because they're so damning, or maybe the school just invoked this, generally speaking, to justify its foregone conclusion. After all, if they determined that 5.5-minute debate at the panel to be aggressive and shocking, warranting a professionalism concern card, Lord knows how they could misinterpret, willingly or accidentally, any social media posts coming from Bhattacharya. So that is an overview of the situation. It'll allow us to save some time on the judgment. Let's just go over the highlights of the judgment. Bhattacharya seeks injunctive relief and damages pursuant to 42 U.S.C. section 1983 for retaliation in violation of his First Amendment right of free speech, count 1, and for deprivation of his 14th Amendment right of due process, count 2, from various individuals at the University of Virginia and its medical school. Bhattacharya also seeks damages for conspiracy to interfere with civil rights in violation of 42 U.S.C. section 1985-3, count 3, and conspiracy to injure him in his trade, business, and profession under Virginia Code section 18.2-499, count 4, from the individual defendants in their official and individual capacities. Defendants filed a motion to dismiss for failure to state a claim pursuant to Federal Rule of Civil Procedure 12b-6. The court will grant defendants' motion to dismiss counts 2, 3, and 4, but will deny defendants' motion to dismiss count 1. We have already gone over the most material facts summarized in that article. I just want to go over a few of the highlights in the lawsuit. Specifically, I want to read the letter in its entirety from the university to Bhattacharya, summarizing their perception of his demeanor during that panel Q&A. The ASAC's letter in its entirety, dated and emailed to Bhattacharya on November 15, reads as follows. Dear Mr. Bhattacharya, the Academic Standards and Achievement Committee has received notice of a concern about your behavior at a recent AMWA panel. It was thought to be unnecessarily antagonistic and disrespectful. Certain Certainly, people may have different opinions on various issues, but they need to express them in appropriate ways. It is always important in medicine to show mutual respect to all, colleagues, other staff, and patients and their families. We would suggest that you consider getting counseling in order to work on your skills of being able to express yourself appropriately. Sincerely, Jim B. Tucker, MD, Chair, Academic Standards and Achievement Committee. So after a 5-minute debate, which some people found to be somewhat antagonistic, even if it were that, you have a doctor telling a guy to go get counseling? I'm telling you something, the only people who need counseling in all of this are the people who are guilty of having done what they did. On the afternoon of November 28, UVA Medical School Registrar Catherine Yates emailed Bhattacharya notifying him that, quote, the Academic Standards and Achievement Committee will be meeting today to discuss your current enrollment status. You are invited to attend to share your insights with the committee, end quote. Within 10 minutes, Bhattacharya responded, who exactly will be present? Do you normally just give students 3 hours to prepare after indirectly threatening to kick them from medical school? Why exactly is my enrollment status up for discussion? Toward the end of the hearing, Tucker told Bhattacharya that, quote, the concern was how Bhattacharya had been coming across to people in the last few weeks, end quote. Bhattacharya said that, quote, he just wished the ASAC members would provide a specific example of what exactly he had said and done, end quote. Another doctor stated that the, quote, entire episode was a very good example of inappropriate behavior and aggressive behavior, end quote. And then they suspend Bhattacharya from medical school. The November 29th suspension letter. The day after the hearing, Tucker sent Bhattacharya an email with a letter attached. The letter in relevant part reads, the Academic Standard and Achievement Committee, ASAC, convened on November 28, 2018 to review concerns that your recent behavior in various settings demonstrated a failure to comply with the School of Medicine's technical standards. The ASAC decided that the nature of the concerns necessitated the calling of an emergency meeting. The Academic Standards and Achievement Committee has determined that your aggressive and inappropriate interactions in multiple situations, including in public settings during a speaker's lecture with your dean and during the committee meeting yesterday, constitutes a violation of the School of Medicine's technical standards that are found at website. The hallmark of pure corruption, if they don't get you on the substance, they're going to get you on the procedure. If they harass you enough, surely they will find something along the way to use against you. And if you can believe, it actually still gets worse. Those standards in relevant part and as related to professionalism state that each student is responsible for demonstrating self-awareness and self-analysis of one's emotional state and reactions, modulating affect under adverse and stressful conditions and fatigue, establishing effective working relationships with faculty, other professionals, and students in a variety of environments, and communicating in a non-judgmental way with persons whose beliefs and understandings differ from one's own. The committee has voted to suspend you from school effective immediately. You may apply for readmission to return to class no earlier than August 2019. The committee would only approve your return if you're able to provide evidence that further violations of the technical standards are unlikely to occur. And if you thought the harassment and psychological abuse ended there, no, it doesn't. It gets still even worse. The January 2019 no trespass order. On December 30, Deputy Chief of Police of the University of Virginia, Melissa Fielding, called Bhattacharya to inform him that the UVA Police Department would be issuing a no trespass order against him. When Bhattacharya inquired into the basis for the NTO, Fielding did not provide any additional information. Fielding sent Bhattacharya a letter with the NTO attached. The NTO stated that for 4 years from its effective date of January 3, Bhattacharya was, quote, not to come on any property or facility on the grounds of the University of Virginia except as a patient at the University of Virginia Medical Center, end quote. The NTO also stated that it, quote, must be appealed in writing to the Associate Vice President for Safety and Security within 5 calendar days, end quote, after service. Bhattacharya appealed the NTO and surprise, surprise, his appeal was rejected, and that is going to come into play as relates to his lack of due process part of his claim. This is one of those cases where the facts are absolutely more interesting than the law. Bhattacharya then went on to file a claim with 4 counts. All but one of them was dismissed, but ultimately all he needs is the one claim that was not dismissed. Bhattacharya's amended complaint and attached exhibits provide some evidence regarding defendants' justifications for their actions. Yet Bhattacharya adequately alleges that defendants used the professionalism standards as a pretext for engaging in content-based or viewpoint discrimination, thereby calling that justification into question. Bhattacharya also adequately alleges that UVA's issuance of the NTO was pretextual. The record is not developed sufficiently at this stage to determine whether Bhattacharya's First Amendment retaliation claim fails as a matter of law. Moreover, such fact-intensive arguments about causation are better evaluated on summary judgment. Quote, based on Bhattacharya's amended complaint, it is unclear whether defendant's behavior was reasonably motivated by his disruptive conduct or unreasonably motivated by his protected speech, end quote. The individual defendants raised an argument based on qualified immunity, which the judge did not retain either. Quote, qualified immunity shields an officer from suit when she makes a decision that, even if constitutionally deficient, reasonably misapprehends the law governing the circumstances she confronted, end quote. Based on Bhattacharya's allegations, the court cannot conclude that the individual defendants are entitled to qualified immunity on the First Amendment retaliation claim. The court goes on to dismiss the other 3 counts of Bhattacharya's claim, but ultimately all he needs is 1 in order to proceed to court and in order to continue to bring this to the public's attention, but let's go over why those other 3 aspects were dismissed very summarily. Finally, nothing in Bhattacharya's amended complaint suggests that he was denied due process with respect to the NTO. Bhattacharya does not claim to have a property or liberty interest in being present on the UVA grounds. In any event, he was given the right to appeal the NTO, which he did in July 2019. His appeal was subsequently denied. For these reasons, Bhattacharya's procedural due process claim under count 2 will be dismissed. Count 3, civil rights conspiracy. Bhattacharya must plausibly allege the following elements to state a Section 1985-3 claim. 1. A conspiracy of 2 or more persons. 2. Who are motivated by a specific class-based, invidiously discriminatory animus to 3. Deprive the plaintiff of the equal enjoyment of rights secured by the law to all. 4. And which results in injury to the plaintiff as 5. A consequence of an overt act committed by the defendants in connection with the conspiracy. Try to say that 5 times in a row. I'm not even sure I said it properly the first time, and I'm reading it. Moreover, Bhattacharya's conclusory allegations lack factual support and do not support an inference that the individual defendants' acts were unauthorized or that they had an independent personal stake in Bhattacharya's suspension. Thus, the court concludes that the individual defendants are protected by the intra-corporate conspiracy doctrine. For these reasons, Bhattacharya's Section 1985-3 claim will be dismissed. And similar reasoning applies to the dismissal of count 4, which was the conspiracy to injure trade, business, or profession. Bhattacharya alleges that the purported co-conspirators conspired to deprive him, quote, of the ability to complete his medical school studies and enter the medical profession, end quote. He does not allege to have any existing stake or interest in a business, let alone one that was the target of a conspiracy. Rather, he claims injury to a future interest in employment, which does not raise a right to relief under the statute. Alright, so that is the judgment, and it gives you a very good overview of the lawsuit itself. I could not believe what I was reading as I was reading it. If they don't get you on the original charges, they will get you on the procedure. And perhaps more important than anything else, this is reflective of the absolute state of university in the year 2021. I would not want to be in university right now. Alright, and with that said, it is time to go. If you like my videos, you like my vlogs, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. Robert Barnes and I do weekly live streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar, and they are awesome. We also have a page on Locals if you want to support us there, where you can get some great exclusive content. vivabarneslaw.locals.com. What else? We're also on Rumble, so you can catch all of my videos there. But more important than any of that, take care of yourselves, check out on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out, Winston. Peace out. Booyah!